Well, by now I'm sure you realize that the president can call in the military against Americans without even asking the states for permission. Let's talk about the Insurrection Act, a law that's as old as the country and is as dangerous as it sounds. So, the Insurrection Act dates all the way back to 1792. It was expanded in 1807 and 1871, and it's been used to send troops into cities like Detroit in 1967 and Los Angeles in 1992. But here's the catch. The law barely defines what counts as an insurrection. And that means the president has a huge amount of power and not many checks. Under the law, there are 3 ways a president can use troops at home. 1, if a state asks for help. 2, if federal law can't be enforced because of unrest. No state permission is needed. 3, if there's violence or conspiracies that are stopping people's constitutional rights. Again, no state consent is required. But here's what should worry you. These terms like insurrection and domestic violence aren't spelled out in detail. They're subjective. It's basically up to the president to say, I think there's an insurrection. Send in the troops. So what's stopping a president from baselessly claiming there's an insurrection and calling in the military? Honestly, not much. The Posse Comitatus Act usually stops the military from acting as police, but the Insurrection Act overrides that. And the courts? Well, the Supreme Court has said in Martin v. Mott in 1827 that the president's decision to call up the military is basically final. They won't question if the threat is real. However, if troops actually violate your rights, you can challenge that in court, like in Sterling v. Constantine, 1932. But by then, the troops are already in the streets. There's also no built-in time limit. Once the president uses the Insurrection Act, they can keep troops deployed indefinitely, unless Congress acts to stop it, which has almost never happened. So what would the founders think about this? They were deeply skeptical of using troops at home. Remember the quartering acts and the abuses of King George? That's why they wrote checks like the 10th Amendment to protect states and the people. But they also knew they needed a way to enforce the law if states failed to act. That's why the original 1792 Militia Acts required a proclamation. The president had to publicly warn insurgents to disperse. It was supposed to be an emergency-only tool, not a blank check for federal power. Today, though, many think the Insurrection Act is way too broad. Groups like the Brennan Center for Justice and some in Congress want to tighten the law, like requiring clear evidence of violence or limiting troop deployments to 14 days. But so far, no reforms have passed. So here's the bottom line. The Insurrection Act is a relic of the founders, meant to stop real insurrections, not to police protests or political dissent. But the language is so broad that any president could, in theory, misuse it if they're willing to cross that line. So what do you think? Should we tighten this law? Should Congress put real checks in place? Drop a comment, because history shows us that emergency powers can be a dangerous weapon in the wrong hands. Hit like and follow me for more deep dives into the Constitution, and let's keep this conversation going, because knowing our history is how we keep our freedoms alive.